I'm going to be doing a deep dive into the Dentons Report on the Real Estate Council of Ontario because there have been no criminal charges. So Joseph Richer, the Registrar of the Real Estate Council of Ontario, and Brenda Buchanan, who was new on the job as the CEO, but she's an old suit of RECO. She wouldn't have even been over her probation considering, but because she came up within RECO, she was. So the new CEO and the registrar, they colluded to bypass the board of directors. They didn't tell them about the 10 million, 8 million, and by the time the administrator showed up, which is just another common sense revolutionary, Jean Lepine, when he showed up at RECO, apparently it became $30 million. What Stephen Crawford's direction to RECO was pretty much a fine when he said, pay up, pay the people that were victimized by you dropping the ball. That's pretty much a fine. That's probably one of the largest fines we've ever seen, but it's not being called that. But the money is coming from RECO, and we don't really know what that amount is because they have given us a range of $22 million. There's no checks or balances. The introduction to the Dentons Report spells out who it was that they spoke to. So they spoke to 14 employees. They spoke to all the board of directors. They spoke to the dismissed registrar, Joseph Richer, and they also spoke to the CEO. They also had follow-ups, and they looked at they had the IT manager for RECO. They requested the email chains and text messages. So all this was provided to them. They had thousands of emails they went through, and this is the conclusions that they came to regarding what happened with RECO and the iPro case. So it's based on a balance of probabilities is how they describe that. That's their introduction. Summary of the key findings of fact. We have concluded on a balance of probabilities that iPro first disclosed a combined financial shortfall of approximately $10 million in its trust accounts to RECO on May 19th, 2025. This information was shared with RECO's registrar in an email sent at 7:08 p.m. on May 19th, 2025. Only 21 minutes later, the registrar sent an internal email at 7:29 p.m. stating that the iPro matter would be a good one to get an undertaking to resign and never reapply. The registrar's determination was made even prior to RECO's on-site inspection at iPro's premises, which took place over a 2-day period on May 21st and May 22nd, 2025. So the registrar, Joseph Richer, had a confession from the two brokers, from their lawyers, saying we're short $10 million in our two trust accounts, but they were running two sets of books, it turns out. But the registrar wouldn't have known that. He didn't bother investigating or looking into things before he made his determination that what the punishment was going to be for the $10 million of missing trust funds was simply, very simple. All the brokers had to do was resign and never reapply. So that's not criminal charges. That's not even a revocation. That's not even the registrar saying, I'm going to revoke your registrations because you've stolen $10 million. No, he decided single-handedly, one-person decision, and he actually behaved as an autocrat to make sure that his decision went all the way through to paint the brokers, to paint the board of directors into a corner because they weren't informed until after he had actually carried through with what he had decided single-handedly. According to the registrar, the intention behind the undertaking agreement was to facilitate the sale of iPro assets from which the sale proceeds would be used to recover the shortfall in the trust accounts, thereby making consumers' registrants whole. The registrar had the authority to pursue the option of an undertaking agreement. However, in doing so, the registrar deviated from RECO's typical approach of a suspension order, freeze order, and request to revoke registration when dealing with and escalating matters involving misappropriation of trust funds by a registrant. The act is called Trust in the Real Estate Services Act, but there was no trust in the trust accounts of the services of iPro Realty, and the registrar failed to inform the board of directors, the public, registrants of this danger, so the trust accounts were not trustable. The accounts were left open to be, they were actually duplicated. The accounts were duplicated is what it turned out. But the accounts were left open for consumers to continue making their trust deposits into, and for commissions to continue be deposited into accounts that had been robbed. So the registrar chose to be a real estate broker rather than to be the registrar. Notably, once the registrar made his determination on May 19th, 2025 to pursue an undertaking agreement as the appropriate response, he appears not to have considered other regulatory options available to RECO. We understand this decision to pursue the undertaking agreement as the only regulatory response was not revisited, despite the fact that the registrar himself expressed concerns about the accuracy and completeness of information provided by iPro prior to the date the undertaking agreement was executed. Other RECO staff had expressed concerns about the registrar's chosen approach, and the undertaking agreement was not executed for approximately 11 weeks after RECO's on-site inspection at iPro ended on May 22nd, 2025. So the registrar made a decision when he received the email, and he wasn't willing to come off of that decision that he made. It was going to be, even though he questioned the information himself, it still didn't matter. He'd made his determination, and nothing was going to change his mind. While the undertaking agreement was being negotiated between RECO and iPro, the registrar failed to impose interim protections that were available to RECO, such as placing a hold on iPro's accounts through a freeze order, or the monitoring of iPro's accounts by either RECO employees or independent third parties, or referring the matter to RECO's investigation team to commence a formal investigation in accordance with RECO's established internal risk investigation procedures. We were told by the involved employees in the regulatory division that RECO focused on negotiating an undertaking agreement because it was originally anticipated the sale of iPro to a third-party purchaser would proceed more quickly than it did. In fact, the undertaking agreement was not executed until August 8th, 2025. So RECO's employees, these are actually the lawyers that would have been negotiating this agreement. So RECO's in-house lawyers wrote the agreement and negotiated the agreement, and they were a part of the mishandling of the iPro case. So the lawyers within the Real Estate Council of Ontario are a part of the apparatus that Joseph Richer left behind. And the lawyers at RECO called Joseph Richer their client. They weren't a consumer protection agency at all. They referred to the registrar as their client, and that's who they served. The delay left the iPro accounts unmonitored and in operation for a period of almost 3 months while iPro and the registrar negotiated the undertaking agreement. Throughout this time, the registrar relied upon the information being provided to him by iPro to verify the value of the shortfall based on iPro's own records, and the registrar did not take sufficient steps to verify the magnitude of the shortfall. These were significant failings on the part of the registrar. What's important to point out here is the registrar had a team of lawyers that were negotiating this undertaking agreement alongside him. So he had an entire team with him that also didn't bother. So nobody was bothering verifying the facts of how much money was actually missing. Further, between May 19th, 2025 and August 8th, 2025, some members of the regulatory division expressed concerns to the registrar about the process followed by the registrar and the deputy registrar, and the use of the undertaking agreement as RECO's chosen regulatory response. These concerned employees felt that the registrar dismissed the concerns raised and that the registrar appeared to have tunnel vision with respect to his chosen solution of negotiating the undertaking agreement, Ultimately, such members did not feel empowered to report these concerns outside the regulatory division at the time, given their understanding that they serve at the pleasure of the registrar, and the registrar had ultimate decision-making authority over RECO's exercise of its regulatory powers. The registrar regularly emphasized these points to employees of RECO. Further, some of these employees who did express concerns about the chosen approach felt that those concerns were simply dismissed and that they were then sidelined from active involvement in the iPro matters. So RECO's registrar wasn't going to have anybody give him any other ideas. He wasn't willing to look at any other options. He'd made his decision, and his decision was final. That's a dictator's decision. We understand that the registrar first alerted the CEO of an issue regarding the potential misappropriation of trust funds on May 19th, 2025. Although it was unclear whether the registrar identified iPro during his initial call with the CEO told us that the registrar shared that the matter involved a former RECO board member, Rui. Though the CEO did ask the registrar for updates from time to time on the matter, these reports were sporadic and not forthcoming. The CEO had moved up in her role. She was already a RECO employee. She was only on the job maybe 2 months. She took over from Michael Beard. So she was definitely an old suit around RECO, but she was new in her role. If she had been hired not from within, she would have still been under probation when this occurred, when RECO's registrar decided that he wasn't going to share information with her. However, as the CEO of a large corporation like the Real Estate Council of Ontario, you should be strong enough for the role. You should be able to get the information that you need because you are the CEO of the corporation and you should be taking your role seriously. During the negotiations with iPro and its principals, the registrar did not disclose details of the iPro matter and the undertaking agreement to the RECO board. You know, the people that hired him. In particular, the registrar attended at RECO's board meeting on May 28, 2025, and provided a report on regulatory matters that did not mention the iPro matter in his written report or orally. As such, the RECO board did not have knowledge or oversight into the approach being taken by RECO, nor did the RECO board have the opportunity to provide input into the approach being taken by the registrar to address the shortfall in iPro's trust accounts. So the registrar and the CEO did not tell the board of directors that employs them that there was a $10 million shortfall. This is very embarrassing for the board of directors. And the board of directors were left in the dark by their employees, the registrar and the RECO. They were employed by the board of directors, and they were absolutely disrespected by being left in the dark. The board chair, Katie Steinfeld, was first notified by the registrar of the issues at iPro on August 10th, 2025, 2 days after the undertaking agreement had been executed. The remaining members of the RECO board received an email communicating regarding the iPro situation on August 13th, 2025. In short, the RECO board did not learn about the iPro matter or the undertaking agreement itself until after that agreement had been executed. So the board chair did know 3 days ahead of the rest of the board of directors. Maybe she told them, we don't know. But the board of directors, they were left in the dark. We find that the board could reasonably have expected that either the registrar or the CEO would notify the board of a matter with the magnitude of the iPro matter and with such high risk to RECO. This is particularly the case given that the board had been actively meeting with and questioning the registrar on another significant educational file that the registrar was handling, which demonstrated that the board wished to be notified of matters involving significant organizational or reputational risk. Further, the registrar reported to all board meetings, including on May 28, 2025, as mentioned above. The board could reasonably expect that he would notify the board of such significant and high-risk matter, but he did not. RECO's registrar, RECO's CEO, did not notify their board of directors regarding iPro. RECO has a standard process in place to address situations where it learns of a potential misappropriation of trust funds at a brokerage. This process generally involved the imposition of a freeze order, a suspension order, and a proposal to revoke registration. Matters that severely impact public trust in real estate in Ontario, including potential criminal matters, are in the severe category under RECO's investigation procedure, which should be referred to RECO's investigation program. The registrar deviated from RECO's standard process in responding to the shortfall in iPro's trust accounts and did not commence a formal investigation. Instead, the registrar attempted an out-of-the-ordinary resolution that he explained was an attempt to prioritize financial recovery through the sale of iPro's assets and goodwill. Our preliminary findings surfaced that RECO's response to the iPro matters was largely attributable to the unilateral and sheltered decision-making of an empowered registrar who failed to leverage the advice, resources, and expertise of the teams that surrounded him. We find that this situation was further exacerbated by an environment at RECO where other senior management often deferred to the registrar. In this specific case, the registrar's deviation from RECO's standard process also created a reasonable apprehension of bias, given that one of the iPro principals, Mr. Rui Alves, previously sat on the RECO board between 2019 and 2023. There was insufficient evidence to conclude that there was a personal relationship between Mr. Alves and the registrar outside of the working relationship, nor did we find that the registrar's relationship with Mr. Alves as a former board member influenced his decision-making. However, we find that the potential for or possible perception of a conflict of interest in this case should have led the registrar to more closely follow RECO's standard process to the iPro trust account shortfall and further to consult more broadly within RECO about the use of the undertaking agreement. So RECO's registrar should have actually tread much more carefully because this was a former director, but he did the exact opposite. He made sure that the former director of RECO was not criminally charged, and all that he had to do was resign, not have his registration revoked, resign and never reapply. So there's definitely the perception of a conflict of interest due to the working relationship, and that former RECO directors are free to do whatever they like, and there will be no repercussions. The inclusion of a non-prosecution provision in the undertaking agreement under which RECO agreed not to initiate provincial offences charges against iPro, Mr. Alves, Mr. Colucci, risked undermining public confidence in RECO, particularly given the magnitude of the trust fund shortfall in the iPro trust accounts. By agreeing to the non-prosecution agreement, the registrar gave up a tool that he could have used to enforce compliance with the Act, encourage general deterrence by encouraging other brokerages to comply with the Act, and the opportunity to show RECO's regulatory effectiveness. However, despite the inclusion of this provision, we accept the preponderance of the evidence that it was RECO's intention to refer the iPro matter to the police once the undertaking agreement was executed. I disagree. I don't know why you would have a non-prosecution provision in an undertaking agreement and then supposedly you're going to refer the case to the police later. The non-prosecution provision was put in more than likely to make sure that there would be no investigation, there would be no charges. The registrar's office was siloed. I've heard this word before with delegated authorities. They keep telling me that I have a siloed attitude towards the delegated authorities. No, they all look the same to me. Pretty rotten. So the registrar's office was siloed. The registrar intentionally kept the functions of the regulatory division generally, and the registrar's office in particular, separated from the rest of the organization. Senior management of RECO had difficulty obtaining information from the registrar. The registrar was experienced, strong-willed, intimidating, and protective of his authority as a registrar. Despite coaching from the CEO, the registrar's approach to his role and his colleagues had the effect of discouraging people from challenging him or raising their concerns to senior management or the board. In our view, this organizational culture contributed to RECO's response to the iPro matters and created an environment in which the registrar entered into the undertaking agreement with RECO and its principals in the absence of considering other available regulatory responses and without an appropriate level of visibility from the RECO board or other members of RECO senior management. So I come back to, again, say this is an autocrat and a dictator that has been running the Real Estate Council of Ontario for 13 years. And that is exactly what this describes. This describes an autocrat and a dictator. So how many more decisions has this registrar been sitting at the Real Estate Council of Ontario deciding who will go to trial and who won't, what's serious and what isn't? Because this is very serious, and he didn't treat it that way. The RECO's registrar and the CEO should be criminally investigated for their involvement in the 10 million, 8 million, 30 million. How many numbers is RECO going to give us? But at the end of the day, it was other people's money that was stolen.